Turn the microphone on. I'm pleased we're holding this hearing today. I think it's an important hearing. This committee needs to conduct some timely oversight into compliance with the Freedom of Information Act. I believe that is our nation's premier transparency law. I think the last time we held a FOIA hearing was back in 2018, as I recall, and I think both Senator Grassley and Senator Cornyn is there. Much has happened since then, including a global pandemic. I look forward to hearing from our consensus government panel on the challenges facing compliance with FOIA, but also ways to increase transparency and the right to know. And I mentioned my Republican friends, Senators Grassley and Cornyn. They have been steadfast. We have worked together. We've tried to make sure that we improve FOIA on a bipartisan basis. And I think the lodestone has been, we have both said, whether it's a Republican or a Democratic administration, we senators want FOIA to work. And the fact that we have been consistent with that has helped a lot. I also might say that in my years here, we reach across the aisle to find common ground. We work better. Now, for those unfamiliar with the Freedom of Information Act, and that's not this panel by any means, but it's not just some wonky statute that open government experts and journalism professors care about. Rather, information requested and released with FOIA is responsible for breaking news stories. They're talked about in living rooms across the country. For example, FOIA revealed that hundreds of millions in taxpayer dollars were wasted in fraudulent payments in the aftermath of Hurricane Katrina. FOIA exposed the Central Intelligence Agency's legal justification for conducting lethal drone strikes against U.S. citizens abroad. FOIA helped shed light on the Department of Defense's questionable track record handling sexual assault and harassment cases. FOIA helped to reveal racial disparities in the harm caused by COVID-19, as well as flaws in the government's response to the public health crisis. And if you hadn't had FOIA, these important revelations and many others would have remained hidden from the public eye. And why it's so important to have this kind of transparency in our democracy? Well, I think that transparency isn't just a nice feature to have in a democracy. Transparency is actually a fundamental pillar of a democracy. The American people's right to know what their government is doing, which is what FOIA does, is essential to protecting against abuses by the powerful. It reflects a simple but profound principle that a government of, by, and for the people cannot be one where the actions of that government are hidden from the people. And it is one of those things where Senators Grassley and Cornyn and I have worked to bring a little bit more sunshine into the government and to the public. We strengthened and updated the Freedom of Information Act. We've enacted amendments several times. In the 2016 FOIA Improvement Act, among other reforms, we enshrined a presumption of openness to help prevent agencies from blindly withholding information without a clear rationale for doing it. But despite our legislative efforts to bolster and update FOIA, the executive branch efforts to comply with the law have been inconsistent and at times very disappointing. And I'd say this is unfortunately a pattern we've seen in both Republican and Democratic administrations. FOIA requests continue to balloon. FOIA exemptions are abused far too often to withhold information that goes totally against Congress' intent passing the presumption of openness. And Congress' proactive disclosure mandates have yet to be seriously implemented, even though we passed them 6 years ago. So we'll talk about all these things. We're not here to point fingers, but what we want to do, how do we make it work better? And I think we demonstrated that Republicans and Democrats want to work together to craft another bipartisan FOIA Reform Act, but we want one that's going to strengthen our premier transparency law. I'll put the rest of my statement in the record, but yield to Senator Grassley.
Well, since you and I have worked together on this particular issue for decades, and sometimes doing things that need to expand the original intent of it to get back to that original intent, I think it's quite appropriate that you're sitting in for Senator Durbin at this hearing. So today we turn our attention to an important issue that's unfortunately doesn't get the attention that it deserves. Government transparency is fundamental to good governance. The Freedom of Information Act is supposed to help ensure this transparency. Congress has a responsibility to ensure that both the letter and the spirit of FOIA are being faithfully carried out by administrations of both political parties. Transparency brings accountability. FOIA is our nation's primary transparency law. It gives the American public statutory right to request government documents. Americans have the right to know what their government is doing. Before Congress enacted FOIA, much more government waste, fraud, and abuse could have remained hidden from public scrutiny. This committee has a bipartisan history of confronting FOIA challenges and strengthening the public's right to know. In 2016, a bipartisan effort led by FOIA Improvement Act of 2016. The chairman's already said how he, Senator Cornyn, and I have worked to get that legislation enacted, but there are still significant issues with the FOIA system. Federal agencies seem to be determined to disclose as little as possible. I want to acknowledge that the Department of Justice recently published FOIA guidelines for federal agencies. That being said, I'm disappointed that it took more than a year for the administration to issue those guidelines. I've heard similar promises before with no real improvement in transparency. So when I hear any administration make promises of transparency, I've learned to take it with a grain of salt. Unfortunately, there's still delays and backlogs in FOIA requests. The Government Accountability Office found that backlog requests increased 18% from 2019 to 2020. And then going back to 2012, backlogged requests have nearly doubled. Another recent government accountability review of FOIA found that agencies use what's known as B3 exemptions. That has doubled since 2012. Instead of increased disclosures, federal agencies have doubled their use of this exemption to withhold information from the public. And proactive disclosure, the Government Accountability Office found that 25 federal agencies didn't report a single proactive disclosure. Now, how is that possible? There's clearly substantial room for improvement, so I look forward to this hearing those recommendations today. Finally, it's not just the public who can't get answers to questions. Last year, I asked the Department of Veterans Affairs for information about allegations that a VA employee leaked potential marketing sensitive information and then retaliated against whistleblowers. Nearly 1 year later, I still haven't received a single document, and that's just one of many examples. Another might be Crossfire Hurricane, where the President Trump, January 19th last year, declassified I don't know how many documents. They're still in the Department of Justice, not declassified, and I asked for those months and months ago. So whether it's congressional oversight, which we have a constitutional responsibility to do, or whether it's through Foia that's available to everybody in the United States to get information, it seems to me we need to make this work, because there's everything about the American government that the public's business ought to be public. Now, I know there's exceptions like privacy. Obviously, national security, you don't tell your enemies what you're going to do, and our intelligence gathering. And if people can add more, but I think that covers practically everything that shouldn't be available for the public's knowledge. So the public's business ought to be public, and that's what FOIA is all about. That's what congressional oversight is all about. Thank you, Mr. Chairman.
Thank you. What we're going to do is have hearing be one government panel. I'll introduce and swear in the witnesses, and then I'll have 5 minutes to make their opening remarks, and then we'll go around to 5-minute questions and back as often as you want. We'll have among the witnesses Mr. James Mc Tate Jr. He's the director of GAO's Strategic Issues Team. He oversees GAO's audits of IRS and a range of issues related to tax administration, policy, and healthcare issues. He's been with the GAO for over 30 years. The primary author of the recent GAO report titled Freedom of Information Act, selected agencies adapt to the COVID-19 pandemic but face ongoing challenges and backlogs. It was just published. Mr. Bobak, Taliban.
I gave you.
I come close to that.
Taliban, that's very close. Thank you.
That list of the people that are testifying.
Taliban.
I'm sorry.
I'm working on it. I'm new here. And he's currently the director of the Office of Information Policy in the Department of Justice, began serving that role in February 2020. The Office of Information Policy is responsible for developing policy guidance for executive branch agencies on the Freedom of Information Act. Before becoming director, he served as acting director, acting chief of staff OIP, and chief of OIP's Foia compliance. Ms. Lena Simo is currently the director of the Office of Government Information Services, well known to this committee, serves as the federal government's Foia ombudsman. Prior to joining the office, she served as the director of litigation in NARA's Office of General Counsel. For that, Director Seymour led the FOIA litigation unit in the Office of the General Counsel at the FBI for over 10 years. Served as Assistant General Counsel in the litigation branch for nearly 5 years. Like myself, she was a graduate of Georgetown Law Center, but decades after I was there. So if you could all please stand and raise your right hand. You solemnly swear that the testimony you have given this matter should be the truth, the whole truth, and nothing but the truth, so help you God. And note that they all did, and we'll begin. Mr. McTeague, would you please?
Senator Leahy, Ranking Member Grassley, Chairman Durbin, and members of the committee. I'm pleased to be here today to discuss the Freedom of Information Act and specifically how agencies adapted to COVID-19. I will also highlight some longer-term challenges that agencies are facing as they strive to improve the public's access to information and promote transparency in government as envisioned under FOIA. During the pandemic, the federal government adopted a maximum telework policy and only allowed on-site work under limited circumstances. This significantly affected how federal employees performed their work. In fiscal year 2020, the first year of the pandemic, Government-wide FOIA requests declined by 8%, but requests processed declined by 12%. As a result, backlogs increased 18% from 120,000 to 142,000 requests. Our review of 5 agencies found that 4 faced temporary challenges that included ensuring employees had access to equipment at home, the ability to receive FOIA requests by mail, and access paper records needed to process some requests. The 5th agency, the FBI, had different challenges due to the sensitive nature of its records. As such, it had to ensure workforce safety on site rather than relying on telework. To assist agencies, the Office of Information Policy at the Department of Justice issued guidance for managing FOIA requests during the pandemic. We found that agencies used the following 3 strategies suggested by OIP. First, agencies increased communication with requesters by posting notices on their websites, alerting them to potential delays in receiving requests by mail and other processing limitations. Second, agencies worked with requesters to narrow the scope of requests based on initial information received. Agencies told us that these interim releases sometimes fully satisfied a requester's information needs and reduced litigation when agencies could not fulfill requests within the statutory timeframes. Third, agencies increased their use of proactive disclosures, making records publicly available, which likely decreased requests for the same information. One agency told us that they closed over 1,000 requests in the last 2 years by directing requesters to information already posted online. While agencies adapted to challenges during the pandemic, backlog requests continue to be a persistent and growing problem. We found that backlog requests have increased by 97% since fiscal year 2012. While most federal agencies had fewer than 100 backlog requests at the end of fiscal year 2020, 16 agencies had backlogs of more than 1,000 requests, representing 94% of the government-wide total. Agencies identified several ongoing challenges that affected their backlogs. First, the percentage of complex requests, those that seek a high volume of material or require additional steps to process, such as the need to search for records in multiple locations, has increased. Second, agencies cited a general increase in litigation, which diverts resources from processing requests. Overall, the number of FOIA litigation cases has doubled since 2012. Third, agencies cited the loss of staff or increasing workload as limiting their ability to address backlogs. In response, some agencies made organizational changes, such as centralizing FOIA operations to speed up request processing. Agencies also cited technology-related challenges, such as the need for upgraded document processing systems. Our work has shown that agencies have had mixed results in reducing backlogs due in part to the lack of formal plans specifying goals, actions, milestones, and a designated official responsible for backlog reduction. In our recent report, we compared selected agencies' backlog reduction plans to leading performance management practices and provided several recommendations to improve the plans. Finally, proactive disclosure can also help reduce backlogs by making information on popular topics publicly available. However, in 2021, we found that some agencies had not fully updated their policies and procedures to reflect current proactive disclosure requirements. For example, 6 recommendations we made to HUD, FAA, and VA to update their policies and better track and report this information have not yet been fully implemented. In summary, the agencies we reviewed were able to maintain FOIA operations during the pandemic, but growing backlogs remain a challenge. Senator Leahy and members of the committee, this concludes my prepared statement. I'm happy to take any questions.
Well, thank you. Thank you very much. And before we go to the questions, we'll next go to Mr. Talbian, Director Talbian, and for his testimony.
Good morning, Chairman Leahy, Ranking Member Grassley, and members of the committee. I am pleased to be here today to discuss the Freedom of Information Act and the Department of Justice's ongoing efforts to encourage compliance with the FOIA. Thank you, Chairman Leahy, and also Ranking Member Grassley for holding this hearing and for your steadfast commitment to the FOIA and support of the mission of FOIA professionals across the government. As a child of immigrants who came to this country to pursue the American dream, it is truly my honor to be here today to discuss a topic that goes to the very core of our democracy and to which I'm proud to dedicate my professional career. The department has long recognized its special responsibility to encourage government-wide compliance with the FOIA, with the principle of openness in mind and under longstanding policies that embrace a presumption of openness. During Sunshine Week earlier this month, the Attorney General issued new Department of Justice FOIA guidelines that underscore the federal government's commitments to transparency. The new guidelines remind agencies to comply with both the words and the spirit of the FOIA by applying a presumption of openness. The guidelines also emphasize the importance of proactive disclosures and direct agencies to continue looking for ways to remove barriers to accessing government records and to reduce FOIA backlogs. I feel very fortunate to work alongside thousands of FOIA professionals across the government who have dedicated their careers to this profession because of our shared commitment to government transparency. There are certainly challenges in administering the FOIA as agencies continue to face high demands of increasingly complex and voluminous requests. Records are being created in volumes and in ways that could not have been contemplated when FOIA was enacted. Recent events have created new challenges as agency FOIA offices moved from a lengthy shutdown in 2019 right into the pandemic. In the face of these challenges, agencies have continued to faithfully administer the FOIA, processing over 2.4 million requests over the past 3 years. As part of the department's responsibility to encourage compliance with the FOIA, my office has worked to mitigate some of these challenges and assist agencies in improving their FOIA administration. These efforts are fully detailed in our report to Congress submitted on March 1st, but I would like to highlight some examples today. We have continued to issue guidance and training to agencies in line with the department's belief that quality guidance and training is fundamental to any successful FOIA program. Recent guidance has concerned agency FOIA administration in light of the pandemic and the Supreme Court's recent decision on FOIA Exemption 5. Additionally, we offer regular live FOIA training to agency FOIA professionals, and we look forward to soon releasing new e-learning training modules to help all agencies ensure that their senior executives, federal employees, and FOIA professionals understand their obligations under the law. OIP also makes available key resources to help agencies in their administration of the FOIA, including the Department of Justice Guide to the FOIA, court decision summaries, a FOIA self-assessment toolkit, and by providing real-time advice through our FOIA counselor service. I am pleased to co-chair the Chief FOIA Officer Council with my colleague from OJS. Since its creation, the Council has served as a platform for agencies to understand common challenges, advance new FOIA initiatives, and identify and share best practices. The Council's two committees regularly meet on some of the biggest cross-cutting issues in FOIA and have provided opportunities for agencies to learn about the various FOIA technologies and best practices. Finally, I'm very proud of the work that we've done to implement the FOIA Improvement Act's requirement to create an online request portal that allows the members of the public to submit a FOIA request to any agency from a single site. The national portal on Foia.gov was released in 2018, and nearly immediately we began enhancing it in light of public user and agency feedback. We are now very excited to be currently working with GSA's 10X team to make it easier for the public to find records that have been released. As we look to the future of FOIA administration, the challenges facing many agencies are at times substantial. Nevertheless, agencies have worked to find solutions, and OIP remains fully committed to encouraging agency compliance with the FOIA. As the Attorney General declared in his guidelines, the department stands ready to work constructively with agencies, with Congress, and with the FOIA requester community to improve processing capacities, reduce backlogs, and make government more transparent, more responsive, and more accountable. Thank you for the opportunity to be here today. I would be pleased to address any questions that you or any members of the committee might have on this important subject.
Well, thank you very much for your testimony, and we'll have Director Simo testify, and then we'll go to questions.
Good morning, Chairman Leahy, Ranking Member Grassley, and members of the committee. I am Alina Simo, Director of the Office of Government Information Services at the National Archives and Records Administration. Thank you for the opportunity to appear before you as part of Sunshine Week to discuss the Freedom of Information Act and OJS's work. Thanks to the enhanced independence that the FOIA Improvement Act has afforded OJS, The views I express today are those of OGIS and do not necessarily represent the views of the President. As the FOIA Ombudsman, OGIS reviews agencies' policies, procedures, and compliance with the FOIA, and offers mediation services to resolve disputes between FOIA requesters and agencies. We use these mandates, along with the Ombuds standards of independence, impartiality, and confidentiality, to identify procedures and methods to improve overall compliance with the FOIA. We advocate for the FOIA process itself, rather than individual FOIA requesters or agencies. The thread that runs through all of our work is building trust in the FOIA process by holding space for vital conversations and using what we learn to raise awareness regarding broad, systemic issues ripe for attention and change. In our dispute resolution practice, we are encountering requesters who are angry and frustrated with the FOIA process. We are also hearing anecdotal stories of FOIA professionals experiencing frustration and burnout. Delays have been the top concern for both requesters and FOIA processors. And the primary challenges that we see are a lack of resources, confusion about the FOIA process, and lack of communication between requesters and agencies. In March 2020, we issued an assessment on FOIA's requirement that agencies provide estimated dates of completion, EDCs, to requesters. Our assessment found that agencies were challenged, even before the pandemic began, to provide EDCs and that agency responses were mixed. We also issued an advisory opinion stressing the importance of compliance with FOIA's EDC requirement and an Ombuds observer providing requesters with tips for obtaining an EDC. We saw the number of requests for OGIS assistance involving delays jump 73% in fiscal year 2021, and for 85% of those, a requester had asked for and was unable to obtain an EDC. Our review of all agency FOIA websites in 2020 showed that nearly 63% did not provide updates on how the pandemic was affecting FOIA processing. We saw an improvement in October 2020, finding that 81% of FOIA programs that received more than 10,000 FOIA requests notified requesters about pandemic-related delays on their websites. OGIS has worked to improve the FOIA process through our active involvement with the Chief FOIA Officers Council and the Foi Advisory Committee. As co-chairs of the Council, OGIS and OIP have convened the Council and its two committees a number of times since the pandemic upended FOIA administration. The Council's two committees have brought together talented and committed FOIA professionals to address technology issues, amplify federal career paths for FOIA professionals, and promote models to align agency resources with transparency. The Foi Advisory Committee, established by the archivist in 2014 and comprised of government and non-government experts in FOIA, has made a total of 36 recommendations in such areas as technology, FOIA training, accessibility, and performance standards. The committee's work has informed several of OGIS's recommendations to Congress that I discuss in my written testimony and that I urge the committee to consider today. These include legislation to address the tension between FOIA's proactive disclosure requirements and Section 508 of the Rehabilitation Act, requesting GAO to study and audit compliance and funding issues as contemplated by the FOIA statute, increased oversight of FOIA, including additional hearings and inquiries, and addressing and increasing funding and resources for agency FOIA programs. The current term of the FOIA Advisory Committee recommends that Congress adopt rules or enact legislation to establish procedures for effecting public access to legislative branch records for congressional support offices and agencies that is modeled after FOIA. To be clear, the committee is not recommending that individual members' offices or committee offices be covered by such disclosure procedures, and recognizes that the legislative branch has been among the most transparent of the three branches of government. OGIS will continue to look for opportunities to improve FOIA compliance through our interactions with requesters and agencies, our work with the FOIA Advisory Committee and the Chief FOIA Officers Council, and through our dispute resolution work. I appreciate the opportunity to appear before this committee and thank you for the continued support that you have shown to OGIS. I look forward to answering any questions you may have.
Well, thank you. Thank you very much. Director Televian, let me direct this to you. I'm pleased that Attorney General Garland issued a FOIA guidelines memo to agencies regarding compliance with the FOIA statute. I think it's an important signal. It says the Justice Department takes the transparency seriously. But I worry that some of the agencies may simply see this as a guidance if there's not enforcement of it. So I have a sort of a two-part question. What specific steps will the Justice Department take to track agencies' progress? And what's the Justice Department prepared to do if agencies are ignoring or simply paying lip service to the memo's directive?
Thank you, Senator Leahy, for the question. The department is fully committed to implementing the FOIA in all of its provisions, including the presumption of openness that was codified in 2016. The AG's guidelines reinforce this. And as we've done with all of our policies, we will continue to provide guidance and training to agencies on these principles to apply the FOIA with the presumption of openness and addressing all of the other items in the AG's FOIA guidelines. And we will reinforce that. As the AG guideline says, the department's Office of Information Policy will issue new reporting guidelines based off the content of the memo. And so we will use our our management of the reporting responsibilities to also continue to reinforce these principles. We are fully committed to this. And I take great pride in not only managing and providing advice on this at the department level, but to agencies across the government.
But if they don't, I'm not sure I fully understand. If they don't comply, what are the?
All of our training and guidance will reinforce this. And as we do with any compliance issue, if we are aware of a compliance issue, we will provide specific guidance to the agency. And again, our reporting will keep agencies accountable to their obligations to faithfully and effectively administer all provisions of the FOIA and the Attorney General's, the principles in the Attorney General's guidelines.
The reason I ask in 2021 report of proactive disclosures, GAO states that DOJ's Office of Information Policy asked agencies reporting 0 proactive disclosures to confirm this was accurate. But they didn't follow up with these agencies. Are you following up with these agencies now that have been delinquent?
Yeah, yes, Senator Leahy, and they're not necessarily delinquent, but we have confirmed as we immediately implemented the GAO's recommendations. And in addition to following up to ensure accuracy, we're ensuring to understand why and to the extent the guidance is needed to provide to the agency's guidance. But it's important to note that the proactive disclosures we're talking about are the proactive disclosures required by the FOIA, which are 4 distinct categories of records. And agencies' FOIA administration, the 119 agencies, the number of requests and the number of records they have under FOIA vary significantly, with some agencies receiving 10 and less requests. And for these agencies, there's just not the possibility sometimes of these distinct categories of records coming up for proactive disclosure. Now, beyond these requirements, the Department of Justice encourages the systematic disclosure of proactive disclosures to increase transparency. And some of these agencies may be and are making those types of proactive disclosures. Our follow-up with a lot of these agencies this past year has confirmed that there are legitimate reasons why they're reporting 0 proactive disclosures under the FOIA's reporting requirements.
Well, let me ask Director Simo on this. You're our federal government's FOIA ombudsman. If you had any conversation with agencies about implementing proactive disclosure policies, and in that, are there some agencies that are good actors and some you consider bad actors? And I'm asking for real candor on this question. I think you'll find everybody on this panel wants to hear the answer. Microphone on.
Talk. Sorry about that. Thank you for that question, Senator Leahy. Yes, of course, I'm going to be candid. I was sworn in, so I will be, of course, candid. What we're hearing anecdotally from agencies, whether, and I wouldn't say there's a bad agency out there, I think all agencies and FOIA professionals are doing their best to try to meet the demands of what is happening. But we're still hearing anecdotal stories about the fact that they're having technological challenges in making proactive disclosures. And that is actually the basis for our legislative recommendation to examine the tension between Section 508 of the Rehabilitation Act and proactive disclosure requirements in FOIA. There's an inherent tension, and agencies are sometimes technologically hamstrung in posting large amounts of data online and making proactive disclosures.
You don't want to specifically go into the good ones and the bad ones?
I'm not aware of any bad ones or good ones at this point, but we're certainly, monitoring and hearing and sharing those stories with you.
Thank you. Senator Grassley.
Yeah, thank you. Thank you, folks, for your testimony. I commended the administration for issuing these guidelines, even though it took a long time to get them out. While we were waiting for them to come out, I signed a letter with Representatives Maloney and Comer, as well as Senator Durbin, Leahy, and Cornyn in February, urging the administration to issue them. They're usually issued early in a new administration. Director Talabian, why did it take more than a year for the Department of Justice to issue the guidelines? To me, this says that the administration doesn't see FOIA and transparency as a priority. So is it a priority, and why did it take so long?
Senator Grassley, it certainly is the department's priority, as written in the AG guidelines, to apply the FOIA with a presumption of openness and embrace open government. The department has been steadfast in its commitment to apply the presumption of openness as codified in the FOIA Improvement Act 2016. And in his first full day of this first full week in office, the Attorney General joined us for Sunshine Weeks to provide public remarks to reinforce the importance of FOIA. Under his leadership, we continue to apply, and our guidance and our training and everything that we've done in my office has applied the presumption of openness. And the Attorney General's guidelines, within pretty much a year, reinforces all of those principles and builds on that work. And not just on focusing on the presumption of openness, but on proactive disclosures, the importance of leadership in the Chief FOIA Officer's role, the Chief FOIA Officer's Council that was implemented by the FOIA Improvement Act of 2016, the importance of training, and much, much more.
Okay. I want to go to the release to one or release to all policy. It seems to me that a release to one, release to all policy would improve FOIA process and reduce the burden of processing FOIA requests. When President Obama was president, he directed agencies to adopt a release to one, release to all policy, but it was never implemented. So to you, Director Talabian, has the Biden administration adopted a similar release to one, release to all policy for FOIA requests that President Obama instructed agencies to adopt? If not, why not?
Thank you, Senator Grassley. The proactive disclosure of records has been a key element of our efforts to promote open government and improve FOIA administration. It is a whole section in the AG's guidelines, not only to just add more requests, post more records, but post them in open formats and so forth. When we conducted a pilot on a release to one, all policy, we engaged in stakeholders both on agency and the public side, and there were some challenges to that. And namely, as my colleague at OGIS acknowledged or identified as well, resources to remediate records to make them accessible under Section 508 of the Rehabilitation Act was a significant challenge for some agencies. So we are still encouraging agencies to make proactive disclosures, and some agencies have and are implementing that at a release to one, release to all level. The FOIA Improvement Act of 2016 codified the principle of posting records that have been requested and released 3 or more times, and we are certainly not encouraging agencies. All of our training and guidance is reinforcing that requirement, which in a sense prioritizes the resources for those requests and records that have shown a level of public interest. But certainly we are encouraging proactive disclosures, on our focus on proactive disclosures is significant. We have a whole chapter on proactive disclosures in our Chief FOIA Officer reports. And so we want to continue working towards a time where agencies can have the capacities to get to the point where they can release more and more records on their websites, getting to a release to one, release to all.
See, this question's been asked, so I'll go to GAO. I'm going to a GAO report, but to ask you my last question, Mr. Tabayan. Released earlier this year revealed concerning details about how long agencies are taking to process FOIA requests, and I won't go into those statistics because I gave them in my backlog. But when there's a presumption of openness, why is FOIA requests so complex? Could you explain specifically what makes a request complex?
Certainly, and I will say that in our reports, in our CFR reports, we do ask agencies about the challenges, and this is the most consistent reason, is the increase in the complexity of their requests. Agencies are more and more seeing requests. They're not just asking for one or two records. That could be multi-part, 15 different types of categories of records or types of records that involve multifaceted searches and complicated searches in records in all different formats. And then these records could be voluminous at times and involve multiple consultations within the departments or with agencies. So these are significant challenges. The requesters, the bar for requesters of what they can ask is not very high, and we want, we're in the service of providing government records and informing the public. But the complexity of the request has certainly increased, and I'm seeing that in my office, and I know agencies have reported it in their CFR reports.
Thank you, Mr. Chairman.
Thank you, Senator Grassley. Senator Feinstein.
Thanks, Mr. Chairman. My conclusion from this is there is a big problem. And if I understand this correctly, in 2020, we received a report from the Government Accountability Office entitled Freedom of Information Act, Federal Agencies' Recent Implementation Efforts. That report contained a number of interesting findings. For example, the report concluded that the backlog of requests under the Freedom of Information Act had grown more than 80% since 2012. Over the same time period, the costs to litigate those requests have risen by 69%. So that's a big problem. And I'd like to know what each member in the panel believes is causing that. My just sort of quick look at the situation is that your volume has increased exponentially, and the ability to respond to it perhaps has not as much. So if I could go through the panel and just see what your reaction is, I'd appreciate that.
Senator Feinstein, as has been mentioned here earlier, complex requests have been a factor most cited by agencies. Technology is wonderful, but what it means is that the public has access to technology, which can just
So
really...
you're saying there are more requests dominantly, and that's the problem?
That's a big factor, and of course litigation as well. And litigation stems primarily from the inability for agencies to meet the statutory timeframes. Okay. Those are the two biggest issues that we identified.
Got it.
Yes, Senator Feinstein, these are the complexity and the volume of requests are certainly the most common that we see in our agency CFR reports, was this also what GAO found. In addition, compounded by some of the challenges that agencies have not seen coming in the past few years. As I mentioned in my opening testimony, going back 3 years, we had a lengthy government shutdown where agencies couldn't process requests, I believe, for about a month, and that went straight into the pandemic. All of these have a compounding impact, but certainly the complexity and the volume of requests is a significant
Well,
challenge.
is it correct? My understanding is that in 2021, the federal government received over 800,000 Freedom of Information Act requests, up 6% from just the year before. So obviously, processing all of those is a serious undertaking. I guess what I'm looking for is what should we do?
Well, we do a lot of, we're taking a number of steps in my office to help agencies meet these demands, from both our role in providing guidance to ensure.
Could you speak directly into the
Yes,
mic?
we're providing a lot. We're taking a lot of steps in my office to help agencies meet these demands, the ever increasing demands, both in terms of providing our guidance and training, but also in providing best practices and workshops on effective systems to process requests, communication with the requester, which we've found key and have had.
That hasn't done it, if I understand the statistics correctly.
It has helped us achieve. I mean, while the agencies have received a high volume of requests, we've also been able to process over the years a high volume of requests, and I think a lot of that is towards those efforts. And we're continuing to work on this.
Well, it would seem to me that don't we need to improve the process of responding to those requests? I mean, if you're going from a situation where there are few to where there's a huge number, which appears to me to be the case, the reasons have to be collated, found if there are good reasons that we do something about it. And I don't know that that's happening now. Any comment?
I can assure you, Senator Feinstein, we're doing everything in our office that we can to help agencies.
So what you're saying is that the volume is going up intensively, that we've received 800,000 Freedom of Information Act requests, and that's up 6% from 2020.
I believe that's right. And since 2012, where the GAO report was focused, the number of requests received and processed have increased steadily.
So my question is, what do you recommend we do about it?
Senator Feinstein, that's the reason I come to work every day, is to try to help agencies with these challenges, and we've seen significant improvements. While backlogs can remain a challenge, significant number of agencies do in the government have low backlogs and maintain low backlogs. We've also, as I said, have a lot of examples in chief FOIA officer reports where agencies have made internal improvements and have individual success stories. So we'll continue to work with agencies in our role to be able to help them implement the FOIA.
Is the backlog continuing to increase?
Since
Yes or no?
we have seen the backlog ebb and flow and have a steady increase over time.
Well, then we clearly need to do something about it. So it would seem to me that it would be useful if there were proposals to us of what we should do.
And we remain steadfast commitment to improving FOIA administration and would be happy to work with the committee on any legislative proposals.
Thank you.
Okay, thank
We'll
you.
go to Senator Cornyn.
Thank you all for being here today, and thank you, Mr. Chairman and Senator Leahy for having this hearing. I think Senator Leahy has pointed out something that we've all seen, and that is we're really fighting human nature in a sense, because we're all happy to trumpet our successes and not so happy to trumpet our failures, or where government's not working the way it should. But nevertheless, we all recognize that the very legitimacy of government itself is based on consent of the governed, and obviously the public can't consent to laws and regulations that they don't know anything about. And so hiding information either by advertence or inadvertence is a real problem. Ms. Simo, when your office was created, the Ombudsman's office, the whole idea was to give requesters an informal means to get information without having to jump through all the hoops and the time and delay of litigation and the like. Can you speak to how well that informal dispute resolution process is working?
Thanks for that question, Senator Cornyn. Yes, since we opened our doors in 2009, we have helped thousands and thousands of requesters. And since the FOIA Improvement Act of 2016, which provided the opportunity for agencies to inform requesters of our services at any point during the FOIA process, we saw a huge increase at the beginning. We have approximately 4,000 or so requesters that we help every year. And now we're seeing them at all different stages of the FOIA process. We see them at the very beginning. They haven't even filed a FOIA request yet, so they're asking for help about where to file. Sometimes we see them after the initial response from the agency. They're baffled. They don't understand. We try to help explain. Or we're seeing them after the appeal and before they want to file litigation. So we're seeing them at all sorts of stages in the process. And we're certainly doing our best to assist them and educate them about the FOIA process.
Of course, the agencies are responding to the requests made by citizen requesters, and it may be that the request is not clear, or maybe it's broad. And is that an area where you can help them target their requests so that the agencies can be more responsive and to exactly what it is that the requester wants?
Sure, we certainly have worked with requesters to hone their requests, and we also encourage them to work with the FOIA public liaison at every agency, who actually knows much more about what the records are that that agency possesses, to try to hone in their requests. We've also heard some frustration from requesters about the fact that their requests are getting shut down too quickly because agencies say they're overbroad and lack specificity. So, we try to follow up with agencies to find out, what is happening and try to resolve some of those bottlenecks.
Mr. McTeague, you mentioned litigation. I imagine litigation over these records is a cause for further delay and certainly expense. Are there means that the United States government could embrace, for example, some sort of other alternative dispute resolution process that might save time and money and expedite the receipt of the requested information?
Well, I think in OGIS we have just such a capability. Beyond that, we haven't really studied the issue, but some of the other methods that we talked about, including proactive disclosure, certainly could help that situation. Also, I think some of the lessons that agencies learned during the pandemic, in part in response to guidance put out by OIP, and I point to interim releases where agencies worked with requesters to help focus or narrow the scope of a request and produce information in a more timely manner that may not have been the full extent of the request, but sometimes that actually satisfy the requester's needs. So I think there are some lessons learned that we can apply going forward in a non-pandemic environment that may help chip away at the backlogs.
Are we still seeing, for example, individuals, citizens requesting, for example, their own records using the FOIA process? It strikes me as a real dysfunction of the federal government where a citizen is requesting their own records, let's say from the Veterans Administration, and then they have to file a public information request for that. I mean, that ought to be a basic government service like any service company or industry. Can you speak to that category of requests, maybe Ms. Simo?
Thank you, Senator. Yes, actually, this goes back to the new AG FOIA guidelines that were issued. We noted that the newly issued guidelines continue to encourage efforts of agencies to remove barriers to requesting and accessing government records, these first-party requests. And in particular, they cited an announcement that the Executive Office for Immigration Review, EOR, would be changing its policy and no longer requiring individuals to file FOIA requests to obtain copies of their own records, which we think is dovetails perfectly with the efforts of the Foi Advisory Committee. The Foi Advisory Committee has been studying that very issue, how to pivot away from using FOIA to access frequently requested records such as immigration files, Social Security benefits information, veterans benefits. And we also were very pleased to see that the AG's guidelines encouraged other agencies other than DOJ to examine whether they have similar or other categories of records that they could make more easily accessible without requiring individuals to file FOIA requests.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Cornyn. Chair Durbin.
Thank you much, Chairman Leahy and Senator Cornyn. Senator Grassley was here earlier. I know this is one of his subjects of great passion and interest, and he deserves great credit, as does Chairman Leahy, for their work in this area. So there are two areas that stand out as I look at the GAO report, which I thank the agency for. And the first one seems to be the volume question, and the fact that, as has been said and repeated, from fiscal years 2012 to 2020, the government-wide backlog of FOIA requests increased by 97%. We're all trying to get to the bottom of this, and the GAO report helps us understand. How much of this, Mr. McTighe or others, how much would you associate with our new mode of communication? In other words, we're not requesting documents, copies of documents, so much as communications through high-tech means, whether it's a text or an email or a tweet or whatever. Has this transformed the whole conversation about FOIA?
Senator Durbin, as I actually mentioned this in my opening statement, that we're seeing records and volumes in different forms that weren't and could not have been envisioned when FOIA was enacted. So I do think that that does have an impact on the complexity and the volume of records that might be responsive to a request.
And just first glance, I would say it's difficult to cull out the things that are relevant and important as opposed to those that aren't when we start dealing with these massive increases in volume. They are all in the nature of a communication, either sent or received. And is my starting point right? It's difficult to grade those in a generic way. They have to be looked at specifically.
Yeah, we look at every record and apply the FOIA faithfully with the requirements of the FOIA. I look at our business to be the business of transparency. And so this is a challenge, a modern day challenge, but it's one that we're working to meet the FOIA's demands.
So is there any speculation about using artificial intelligence to make this a more precise delivery of information?
Certainly, we're definitely looking at advanced technologies, including artificial intelligence, to help us with the search and even maybe the processing of records. And this is something that we've been very proud as co-chairs of the Foi Advisory Technology Committee, have a working group on artificial intelligence. We held a workshop as a primer for FOIA professionals to learn about artificial intelligence and see it certainly as the next wave of tools that are going to be significantly helpful for administering the FOIA in the modern day.
Is our federal government flirting with the idea or serious?
I would say we're very serious. We want the best tools because at the end of the day, we want to be as responsive and apply the law as fully and effectively as we can.
Let's move to the second item that came off as important to me in the GAO report, and that's the question of litigation. Can you describe in general terms the proliferation of litigation, how it occurs, and at what level?
Certainly. We've seen, actually this past year litigation did dip actually slightly, but since 2012, there's been a steady increase in litigation. It's a small percentage of the 800,000 requests that agencies receive and process, but it does demand a significant amount of resources. And we see litigation coming in all different types.
Give me a couple examples that you think really account for the largest increase.
Well, certainly when there is a topic of significant interest, a FOIA requester might be incentivized to file a lawsuit closer to the statutory timeline, where depending on the complexity of the request, the agency may not have the ability to respond to that request within the 20 or 30 days. That's certainly one example.
Can you give me a more specific example, the type of thing that the ordinary person would understand? Oh, that's what a FOIA litigation is all about.
Well, first and foremost, Senator, for us, we want FOIA litigation to be the last resort. And so we encourage and try to advertise all the different avenues before a agency or requester gets into FOIA litigation. One of the key ways that we do that is one through communication. We have multiple articles of guidance that stress the importance of communication, so that if you're talking to the requester, you can explain to them why maybe they don't, they do have a complex request. They may not understand how our record systems work or why their request is complex, and that we can work together to provide maybe a more simplified request that gets them the records they want in a much quicker time. We've seen that to be a proven success story. Also, when that doesn't work, issuing interim responses, not waiting until the entire request can be responded to, but providing records as you can, so that the requester can see, oh, well, this is what I was interested in. Maybe they're not interested in going forward. Or once they see a selective response, they can maybe be more confident in tailoring their request to be simpler. Also, each agency, we have guidance on the importance of FOIA requester service centers and FOIA public liaisons to work with requesters, not only explaining their handling of FOIA requests, but to do dispute resolution. We also advocate for very robust, we have guidance comprehensive on the administrative appeal process, where a requester can go to the agency and get an independent review of the agency's initial action. And then finally, it has been long-standing our policy in administrative response letters to notify the agencies of OGIS's mediation services. And since the codification of the FOIA Improvement Act, including those also in our initial response letter. So we want to give all these different tools and avenues for the FOIA requester not to have to seek FOIA litigation. And that's really where we put all our effort.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. And I understand Senator Blackburn is joining us remotely. Is that correct?
That's correct, Mr. Chairman. I had been in the room when you gavelled, and I am going to come to you remotely. I do have a couple of questions. I wanted to go to the public interest standard. Congress enacted the foreseeable harm standard in 2016. Of course, we all know that, and I want to see where each of you are on the issue of having a public interest balancing test to require the agencies consider the public's interest and balance that against the interest of the agency and the interest the agency seeks to protect by withholding requested information. And Ms. Simo, if I'll start with you, and then if everyone will weigh in on that.
Thank you for that question, Senator. I can say that we have heard from the requester community. There's a lot of interest in, I'm not sure where to look. There's a lot of interest in the proactive disclosure standard being applied to more than one exemption. There is certainly a perception that it should be applied to all the exemptions. And I think from OGIS's perspective, we see some issues associated with applying it to every single exemption. For example, exemption 1, national security. We think public interest may not be appropriate to be applied there. So we're very happy to work with the committee if there's a legislative proposal, and we would like to consider it further.
Thank you. Okay.
Senator,
Yeah.
yes, Senator, we are steadfast in our commitment to applying all the requirements of the FOIA, including the presumption of openness and the foreseeable harm standard, as opposed as far as any legislative change or legislative proposal. I can't speak to anything along those lines today, but the department stands committed and would be ready to work with the committee on any legislative proposals.
Okay, Mr. Mc Tate.
Yes, Senator. As embodied in FOIA, there is a balance between public disclosure and the need to withhold information. A lot of thought was put into the crafting of FOIA by the Congress and the committee, and I would defer to the Congress on that.
Okay, thank you. Ms. Emo, I want to come back to you on the backlog site. In the report that we got, it was attributed, much of the backlog was attributed to the general increase in litigation as kind of a challenge. And so I'd like for you to just talk a little bit about how you've changed the standard on these complex requests.
Thank you for that question, Senator. And I didn't have a chance to answer earlier when Senator Feinstein asked a question, but from our perspective, we see the primary challenges for FOIA today is a lack of resources, confusion about the FOIA process, and a continued lack of communication between requesters and agencies. We definitely continue to see FOIA to be largely a resource issue. I want to point out, I believe Mr. Talibian already pointed out, litigation is a very small percentage. I believe we usually cite 1% of all the FOIA requests that the federal government receives. It does prove to be very time-consuming for agencies. We certainly hear stories that agencies are inundated with litigation and are having trouble meeting that.
Okay, let me ask you this, and Mr. Talibian may want to jump in on this. Does this attribute to the increase in the denials, the complex nature, the litigation, because we know that the denials have increased by 32%.
Thank you for that question. When we look at the calculations of and if you're talking about the full denials,
Yes.
we, in looking at it as far as a percentage of the requests that the agency process in a given year, we don't see a meaningful increase. Obviously, the more requests that agencies process, the more opportunities for different dispositions. Ultimately, the dispositions of a request will come down to the nature of the records being requested and the appropriateness of their release. That's why our office is fully committed to ensure agencies have the proper training, guidance, and the resources to properly apply the FOIA, regardless of volume, and apply it with a presumption of openness.
Thank you. Thanks, Mr. Chairman.
Thank you very much. Thank you for joining us, and I'll now yield to Senator Whitehouse.
Thanks, Chairman. Thanks to the panel for being here. I want to discuss a particular aspect of FOIA enforcement related to Exemption 5, the exemption for so-called pre-decisional materials. The logic of that exemption is that the chief executive is entitled to a robust debate among his or her subordinates in order to make the best quality of decisions. And those subordinates should not be playing to the galleries in the recommendations that they make in those debates. And therefore, the pre-decisional memoranda and conversations that lead to an agency decision should be protected. Is that a pretty fair description of what that's all about, Mr. Talibian?
Yes, the exemption protects pre-decisional and deliberative information, but of course we also apply the foreseeable harm.
So the concern that I have is that DOJ recently has tried to apply that exception, that exemption, in a case where there was no decision to be made. And when I say no decision to be made, I mean no formal agency decision to be made. I think there's a difference between a formal agency decision or a formal decision by the head of the agency and just the day-to-day decisions that people make all day long, the quotidian decisions about where you go next and what you eat for lunch and when you have your meetings and who's in the meeting. And everything in life is a decision. So if the exception is not going to swallow the rule, it has to connect to an actual agency decision that presumably has to be a formal agency decision. And what has happened in this case is that the Department of Justice, defending an internal report of its own that connected to no agency decision because there was a policy that drove the decision. So there was no decision to be made because the policy already existed and drove the outcome, was, I think, a very extreme view of the reach of pre-decisional. And I think once you untether Exemption 5 from an actual agency decision, it swallows the rule, and you will be enmeshed in enormous litigation, and there's no real discipline to decide, other than the agency's own prerogative, what it wants to disclose or doesn't want to disclose. So could you tell me, just for starters, what your role, Mr. Talibian, is in the establishment of the substantive rule at the department regarding the Exemption 5 and what is pre-decisional? Do you actually give advice about that, or are you more implementing advice that OLC and others have come up with? Let me just ask it that way.
Senator, my area of expertise is the FOIA, and I provide guidance on the FOIA to the department as well as agencies government-wide.
The case that I'm referring to is in litigation in the D.C. Circuit right now as Citizens for Responsibility and Ethics in Washington versus the United States Department of Justice. Did you advise the department in that matter? The substance was a report that was done related to the Mueller investigation, so-called. And the subject of the report was whether the President of the United States could be charged. And because the department had a policy that the President of the United States could not be charged with a criminal offense, period, end of story, it did not strike me or, frankly, courts as pre-decisional. Were you involved in advising the department with respect to that question?
Senator, that, as you mentioned, is a case that's currently pending before the D.C. Circuit Court of Appeals. As a matter of longstanding DOJ policy, I can't comment on ongoing litigation.
I'm not asking you to comment on litigation. I'm asking you to just ask whether you participated in that discussion.
It's I can't speak to the internal processes of the department, especially with ongoing litigation.
I can't speak to whether you, as the person charged with giving advice, actually gave advice in this matter?
Senator, I can tell you that as part of the processing of requests for the senior leadership offices, I was involved, but so are many others, and I cannot speak to ongoing litigation.
I don't ask you to speak to ongoing litigation. I'm a former attorney general and U.S. attorney. I'm well aware of that distinction, but I asked you a completely different question, which was, did you have a touch point on this in your role?
Yes, OIP was involved in that FOIA case.
Bingo. See, that was actually pretty easy once you got around to answering it. The reason I bring this up for the members is that in addition to the decision the department has made to allow itself to claim this exemption even when there's no actual decision, which allows the exemption to just run wild through the agencies, they've also taken the position that congressional requests for information are governed by FOIA. And so, as a member of Congress, if we are asking an agency for materials under the United States Constitution, exercising our right of oversight, we have to go through all the FOIA hoops. And so when the department is setting up its rules for how and when it responds to FOIA requests, how and when the executive branch responds to FOIA requests, they are also de facto setting up the rules for how we in Congress can get access to the information that is necessary to do our jobs. And I think we need to pay a lot more attention, not just to FOIA as an avenue for the public to hold agencies accountable, but to the question of FOIA as a screen behind which the executive branch can hide from congressional oversight. And I'll close by asking unanimous consent that my brief in that Crew case be made a matter of record in this committee hearing. which is joined by the chairman, I should add.
Without objection.
Very grateful to him and also Senators Wyden and Blumenthal and Hirono and Warren and Booker for participating in that brief. Thank you. My time has long
Objection to
expired.
order. And I have testimony for the Center for Investigative Reporting, Open the Government Project and Government Oversight and Public Citizen, and ask consent those be inserted in the record, and they will be. I would note for the Senator from Rhode Island, sometimes I find on another committee that I chair, appropriations, that sometimes I find that asking questions when an agency's budget is before us, I get the answers a little quicker than I might with FOIA.
Just an observation, right, Chairman?
Just a coincidence.
Just a coincidence.
Purely coincidental.
Senator Tillis, who has been very active on this and has sat here patiently all day. Senator Tillis, please go ahead.
Thank you, Mr. Chair. Thank you all for being here. Mr. Talibian, I know that at least based on the information my staff had provided me, that the B3 exemptions seem to have gone up substantially over the years. I think between 2017 and 2019, it's almost 91% increase. Can you describe to me what factors would lead to that increase in exemptions?
Certainly. And again, when we've looked at it with regard to comparing it to the percentage of requests processed from year to year, it's not nearly as significant. But I think the important thing to note about Exemption 3 is that it's incorporating into the FOIA the non-disclosure provisions of other statutes where agencies generally do not have any discretion. If the information applies, they must protect. But we are at OIP doing a number of things to make sure that agencies properly apply the Exemption 3 statutes. One, we're providing agencies with updated lists of what courts have found to qualify as Exemption 3 statutes, so they know that these courts have said these are proper Exemption 3 statute. Secondly, as agencies are reporting in their annual report, Exemption 3 statutes that we cite, we look and review the ones that have not qualified by the courts or have not been reviewed by the courts to ensure that we believe that they have the proper elements of Exemption 3. And then we make that list available so agencies can see what we are seeing as proper Exemption 3 statutes. Additionally, we have a FOIA counsel service line where we invite agencies to reach out to us if they have a question of whether an Exemption 3 statute applies, is an Exemption 3 statute, and whether the information they're reviewing, if they have any questions of whether it fits within that statute.
Just back on the broader issue of backlog, what is the Attorney General's office doing? I think Ms. Seema mentioned resources. What specific actions are you all taking or request before Congress that can help reduce the backlog, up to and including some of the backlog I have to believe has to do with COVID-19 and the workplace challenges?
Thank you, Senator. So as the AG's guidelines emphasize, timely disclosure is a key element of the presumption of openness. And we're looking at a number of ways to attack or try to reduce the backlog, including helping agencies fight the right technology, making sure they have effective systems in place. And so we do a lot of that too with our reporting. We ask agencies to explain and review their systems to make sure they have effective systems, reassess and assess their technology to make sure they're equipped with the right technology to process requests. We also have a self-assessment toolkit. We encourage agencies to use an evidence-based, objective approach based off our toolkit to looking at each part of their FOIA process to see if there's needs for improvement. Through all these many ways, we're trying to help agencies, and we look forward to building on that.
Are there any specific actions that we could take that would help facilitate that process, congressional action?
I really appreciate your commitment to FOIA, and the department stands ready and would be happy to work with the committee on any legislative proposals, reviewing any legislative proposals.
Okay. Mr. McTeague for the GAO is basically the same question.
Yes, I just reiterate, resources are always an issue. Investment in technology is expensive, but needs to be continuous. But I also emphasize what we heard from a number of agencies and OIP and OGIS as well, and that is the investment in people. The nature of the challenge is changing. Some of the witnesses have talked about The technology we have today was never envisioned when FOIA was first passed, and that has created the ability for the public, which is good, to access more information very efficiently. The government has to keep up with that technology and the training of people. It's not just a matter of collecting paper records anymore. It's complex information retrieval and data management systems, and people trained to operate and manage those systems.
Are there specific people, process, technology projects underway right now? That instead of just incremental changes to underlying systems, are there any major projects or proposed projects underway within the agencies?
One agency that we looked at in our current review, the Department of Labor, has a multi-year project to upgrade their system, and they continued moving that project ahead during the pandemic. It's still yet to be complete, but there's hope there. And other agencies that we worked with also were looking, planning, and hoping to invest in their systems. But I defer to my other witnesses.
Ms. Simo?
Senator, yes, I was just going to bring up the fact that last month we sponsored OIP and OGIS co-sponsored a next generation FOIA tech showcase where we invited 18 different private vendors to come and speak about their technology. And we had a significant agency participation. A number of agencies are looking at different technologies. 20 agencies in particular are in a tough place because FOIA Online, which is their portal that they communicate with requesters, is, as we understand it, being sunsetted by EPA in 2023. So they're really interested in trying to find different technology that they can use. But technology costs money. A lot of agencies can't afford the technology that is out there. There's some great technology, but it's very expensive.
Thank you. Thank you, Mr. Chair.
Thank you very much, Senator Tillerson. Thank you for your work in this area. I'm told Senator Ossoff is going to join us remotely. Is that correct? Senator
Yes, thank you, Mr. Chairman.
Go ahead.
And thank you to our panelists. Thank you for your service. Mr. McTeague, I want to pick up a point you just made to Senator Tillis. You noted that digitization has, in some ways, increased the demand for FOIA production and made it easier for citizens to place broader and more frequent requests. And you noted that these records are, decreasingly paper records or cards or microfilms, but increasingly the records themselves are digitized. What's the relationship between the digitization of records storage by the government and the capacity of agencies to produce such records when requested by the public via FOIA?
Senator Ossoff, we actually did not look specifically at that issue. I would defer to the other witnesses who may have relevant information.
Sure, Mr. Talibian, why don't you take a crack at that? This, I think, is a basic question about how FOIA is operating in the context of new technology.
Yes, certainly. I would say we still are receiving requests that would implicate both electronic and paper records. But as we are having new forms of electronic communication, certainly if you think back to prior to email, the number of records and the types of records that were being preserved and that would be requested were way different. As we get into this new age of even more different forms of communication, we're working with our records management laws, policies, and experts to be able to more efficiently search those records and provide responsive records.
Yeah, what part of the process of response is the most staff time intensive?
Well, I would say that would potentially depend on the type of request. So depending on the request, it could be that the search, because it requires a multifaceted search, a complicated search of different areas, and potentially a lot of key terms, or that could certainly contribute. But also, if the request is broad, has voluminous records that are responsive, calling through those records and then also weighing the equities, having multiple consultations that are required. So then the actual processing of the request could be very time consuming. So it's really dependent on the request, and any part of that process could require a significant amount of resources depending on the request.
Are there agencies that store significant digital records in non-machine readable formats, or that have not run processes to make those records searchable?
So I don't have, in our reporting, I think anything that I could point to that.
Okay, will you find out?
I'm sorry?
Will you find out, please?
I could take that back and see if we can look into it.
Okay, thank you. Mr. Talibian, I want to talk about the 1984 interpretation by OIP with respect to the definition of withholding information from Congress. FOIA states the executive branch cannot use the law, quote, to withhold information from Congress. It doesn't say to withhold information from congressional committees, nor does it say to withhold information from committee chairs, nor does it say to withhold information from Congress pursuant to resolutions passed by Congress. Nevertheless, OIP's interpretation is that requests from individual members don't trigger the special access procedures under FOIA, and that it must be from a committee or a committee chair. What is the negative impact of that, Mr. Talibian, on the ability of Congress and members of Congress to access information in the public interest?
So, Senator, the purview of my office and my area of expertise is specifically to responding to FOIA requests. Our Office of Legislative Affairs works with the committee on congressional oversight requests.
Yeah, this is OIP guidance from 1984. So unless I'm mistaken, Mr. Talibian, this is your office. OIP guidance states that individual members of Congress are not entitled to access consistent with our oversight responsibilities on the basis of this law, that it must only be committee chairs, committees, or the bodies as a whole. Are you familiar with this OIP guidance?
Yes, Senator. And to the extent, I could say we are committed to applying the provisions FOIA to the full extent that we believe is appropriate and possible. But as far as congressional oversight requests, within or beyond that, I would defer to our Office of Legislative Affairs.
I'm not asking about requests beyond that. Does OIP have any plans to review or reconsider this 1984 guidance? It's been a long time, and there are many who credibly argue, I believe, that this interpretation prevents members of Congress from securing records that are necessary for us to fulfill our oversight obligations.
Senator, I appreciate that, and I will take that back as well, and we'll respond.
Okay, so you'll send me, please, something written, a decision whether or not OIP will revisit that guidance?
I will take a look at that guidance and take it back and provide your response.
Okay, with your indulgence, Mr. Chairman, just one more question.
If the Senator just yield for a moment, I wasn't quite sure I understood that answer. Are you going to respond to the Senator's question? And if so, I would want that response to come to the committee also. But are you saying you will respond to the Senator's question, or you're going to take it back and consider it?
I'll be happy to take it back and provide a response.
Thank you. Go ahead, Senator Ossoff.
Thank you, Mr. Chairman. I appreciate it. This is a question for Mr. Talibian and for our witness from GAO, Mr. McTeague. It's a question about how wide the gap is between FOIA as it was envisioned and FOIA as it's been implemented. My impression is that the chasm is massive. It's vast. We're talking about timelines that are worse than routinely unmet, but almost never met. We're talking about massive backlogs. First of all, Mr. McTeague, is that a valid characterization, or is that too harsh?
Well, I would say that during the pandemic, backlogs did increase considerably from, 120 to 142,000 requests. And 16 agencies had backlogs in excess of 1,000 requests. So I'll just state the facts.
Mr. McTeague, my impression is that we're talking about also simply routine noncompliance. Folks have to either sue or somehow get a special counsel investigation in the case of noncompliance. Powerful media organizations have a difficult time getting records to which they're entitled via litigation through FOIA, let alone ordinary people. I mean, how vast is the gap between what this law was intended to do, a presumption of openness, opening government records to the public, and its implementation in practice?
Well, I think if you look at the percent of requests that were denied and partially denied, I think the most recent data that we looked at showed only about 4% were denied outright. Partial denials were in the range of about 40%. That number has gone up since 2012, where it was about 30% of requests received or processed. The outright denials has actually gone down since 2012.
And timeliness?
Timeliness has bounced around, no real perceivable trend.
Mr. McTeague, thank you. Thank you to our witnesses. Thank you, Mr. Chairman.
Well, thank you. We will leave the record open for a week in case other senators wish to submit questions. I would, I think of the problem we have, and this is caused a lot of it by Congress, with ATF, for example, having paper records. And I know what a frustration that is to law enforcement and prosecutors because of that. But I'm going to ask a question for both Director Simo and Director Mc Tate. If you had to highlight just one or two interventions for either Congress or agencies to make in order to fundamentally improve our FOIA system, what would they be? And Director Simo, please answer that, and then Director McTeague.
Senator Leahy, thanks for that question. We actually provided some recommendations in our last annual report to Congress. So we really invite you to go back to look at those, but I just want to summarize them. Several of them come from recommendations that the Foi Advisory Committee has made. We recommended that Congress ask GAO to pinpoint systemic and or specific compliance issues at agencies that Congress could then address. And we were really pleased to see that Senator Durbin, Grassley, yourself, and Senator Cornyn, along with Chairman Carolyn Maloney and Ranking Member James Comer, tasked GAO earlier this month to conduct a government-wide survey, convening focus groups of a representative sample of FOIA officials to examine FOIA backlogs. So that is very, very welcome. The FOIA Advisory Committee also recommended that Congress address funding and resources for agency FOIA programs. And so we recommended that you ask GAO again to conduct a study of funding for agency FOIA programs, which we believe is deficient and would really help agencies tackle their backlogs and help FOIA professionals. And I just want to add one other thing, Senator, which is one other thing that I think is very important for us to keep in mind is that at a majority of agencies, really most agencies, other than the National Archives and Records Administration, FOIA is not the primary mission of that agency. So as a result, what we see is that FOIA programs do not receive the needed attention and funding that they probably deserve. So we would really like to see that focus shift in the future. Thank you.
Thank you very much. And Director McTeague, the same question.
Yes, Senator Leahy. In our most recent report, we made a recommendation to OIP. As we've been talking about today, FOIA is all about transparency and information so that citizens can have a better understanding of their government. Our recommendation to OIP was to take a look at the reporting that agencies do in terms of the FOIA activity and come up with ways to highlight or identify emerging trends, such as litigation that we talked about, such as unusual requests. And with that information, OIP agencies, and the Congress, this committee can, respond to those emergent challenges. And they vary over time and they vary by agency, but with better information available to this committee and the public, we can then target any responses that could help the overall FOIA process.
Thank you very much. As I said, I'll leave the record open. There will be some other questions for the record, and certainly, one, I appreciate all three of you being here, and if you, looking back over it, there's additions you want to make to any of your answers, the record's open for that too. With that, we stand in recess.